We return to the criminal code, Pauline. Isn't this fun? Isn't this totally fun and amusing to see exactly what you work for? So, this Codified Crimes Act, who codifies the law, Pauline? Who actually comes and puts a military codified law over the top of a de jure People's Crimes Act, and then starts repealing from the Crimes Act and relying on the codified law, Pauline? Who does that? Would an occupying military power do that, Pauline, in the absence of a kingship, Pauline? We said we'd return to Division 10, circumstances involving external factors, Pauline. External factors. 10.1. Intervening conduct or event. A person is not criminally responsible for an offence that has a physical element to which absolute liability or strict liability applies if the physical element is brought about by another person over whom the person has no control, or by a non-human act or event over which the person has no control. Well, I'd say you all have full control. So it's not an intervening event in this respect. But I'm intervening here. And I'm saying to you, Pauline, follow the law. The person could not reasonably be expected to guard against the bringing about of that physical element. Well, I can't be physically expected to stop what is a war crime power, Pauline. It's just not possible, is it? Duress, 10.2. We're just going to look through this external factors, Pauline. Duress. A person is not criminally responsible for offence if he or she carries out the conduct constituting the offence under duress. Would that be when the police put you under duress, when they break international law and think that they can stomp all over you with their guns and their police attitudes? Is that right, Pauline? Is that being under duress? Or is under duress being part of a party in a parliament, because a party is a corporation, and being a member to a corporation and not being able to speak for your constituents because you're held to a party line? Is that duress? A person is not criminally responsible for an offence if he or she carries out the conduct constituting the offence under duress. Under duress. You have to define what duress is here, Pauline. Sudden or extraordinary emergency, Pauline. A person is not criminally responsible for an offence if he or she carries out the conduct constituting the offence in response to circumstances of sudden or extraordinary emergency. Is it an extraordinary emergency when a conspiracy and criminal law has been broken by the office of Prime Minister and those around him, like the Greens and the Communists behind him, like West Partners? Is that an extraordinary emergency when the Governor-General gives the green light to do a Rule 92 offence across a country at which he administers under the Hague Conventions? Is that an extraordinary emergency, Pauline, for speaking up? 10.4. Self-defence. A person is not criminally responsible for an offence if he or she carries out the conduct constituting the offence in self-defence. Now, is it self-defence to protect yourself from a foreign policy enforcer that continually breaks the law by committing international law criminal offences? Is it all right to defend yourself against a state that is now known to be a criminal? Is that okay, Pauline? Like, these are real questions here, because if you can't keep these people to account, who is? And this is where we get to 10.5, everybody. Lawful authority. A person is not criminally responsible for an offence if the conduct constituting the offence is justified or excused by or under a law, Pauline. So, being in the kingship as put there by men who defined that on a court record. Is that lawful authority, Pauline? Having a curial right so defined by Justice Lonergan of the New South Wales judicial system, Supreme Court, in 2021, in full correlation of the Crimes Act 1900 New South Wales, Pauline. Okay, so in correlation to that, what would that mean in relation to 10.5 lawful authority? Who has lawful authority, Pauline, if they are war criminals, if they are fraudulent in their money systems? Who has lawful authority if bondage and slavery occurs, Pauline? Who has lawful authority if Rule 90 and Rule 92 offences occur, Pauline? I'm just trying to wrap my head around how in any way, shape or form you believe you have any authority in that parliament, Pauline, having committed some of the most heinous criminal offences before the entire world. And unfortunately, catching up with all of you in the United States, in Australia, and in Canada. The English are a bit slow here, but they'll catch up soon. All right? But lawful authority is in a crown, isn't it, Pauline? Lawful authority is in something that created the Constitution in the first place, isn't it, Pauline? Lawful authority is in a line of authority called lineage to ancestors or ancestry, otherwise known as forefathers, our fathers in lineage. Isn't that the whole ideal here of lawful authority, Pauline, at 10.5 of the Criminal Code? And then if we scroll back up, 9.5, a claim of right. A person is not criminally responsible for an offence that has a physical element relating to property if, at the time of the conduct constituting the offence, a person is under a mistaken belief about the proprietary or possessory right, and the existence of that right would negate a fault element for any physical element of the offence. So as administrators who have been in a criminal action yourselves, namely an international criminal offence, Pauline, does that give you a right, a claim of right, to relating to property? And that property, what would if that property was the Constitution, Pauline? Well, what if that property was actually the Constitution, Pauline? And that curial right was that claim of right, Pauline? And then the line of authority at 10.5, lawful authority, can be defined by Justice Lonergan very clearly on the Supreme Court of New South Wales, making this very, very relevant to the High Court, Pauline, very, very relevant to a precedent that has been set so that the High Court can look at it. And this is very relevant, Pauline, because I'm going to scroll up now because this is a very short section and we're just going to cover some of these other things that are in above it. So we go through 8, intoxication, and this is where I believe that you're intoxicated on power, Pauline. You're all intoxicated on dollars. You're all intoxicated on the IMF and the WEF partners. You're all intoxicated with a lie. You're all intoxicated with the power that you've been given, that you think has a power to control all of these children. And you haven't realised the curial power that stands up next to it. Now, circumstances in which there is no criminal responsibility, mental impairment. A person is not criminally responsible for an offence if at the time carrying out the conduct constituting the offence, a person was suffering from a mental impairment that had the effect that A, the person did not know the nature and quality of the conduct, or B, the person did not know that the conduct was wrong, that is, the person could not reason with moderate degree of sense and composure about whether the conduct as perceived by reasonable people was wrong, or C, the person was unable to control the conduct. This is kind of amusing, Pauline, given that the very specific definition of deluded or delusion comes to the fore on the Supreme Court of New South Wales court record before Justice Lonergan. Now, a mental impairment would be a delusion, wouldn't it? To be deluded would be a mental impairment, wouldn't it? And to believe in a falsity would also be a mental impairment, wouldn't it, Pauline? And at a curial standing, now so defined on the court record as not being delusional, Pauline, then are you deluded to not recognise it? Do you have a mental impairment as a senator to not recognise lawful authority? It's a real question, Pauline. I'm not mucking around here. We're talking about the criminal code here. We're talking about some real world offences here, Pauline. This is not a joke. This is far from a joke, Pauline. Do you have a mental impairment to not recognise a real claim of right, Criminal Code 9.5, okay, of lawful authority, Criminal Code 10.5, making it a mental impairment to not know the nature and quality of that conduct, Pauline? A mental impairment to not know that the conduct was wrong, i.e., that is, the person could not reason with moderate degree of sense and composure about whether the conduct as perceived by reasonable people was wrong. And that applies to you. You have a mental impairment as to the reality behind it and believe what you're doing is right when it is in fact wrong. A mental impairment. And this is defined on the criminal code. So, absolute liability. If a law that creates an offence provides that the offence is an offence of absolute liability, there are no fault elements or any of the physical elements of the offence, and the defensive mistake of fact under section 9.2 is unavailable. Strict liability. It puts the fact under section 9.2 as available. So absolute versus strict liability. I'll just repeat. Absolute liability. If a law that creates an offence provides that the offence is an offence of absolute liability, there are no fault elements for any of the physical elements of the offence. It is the direct breaking of that offence. Whereas a strict liability may have fault elements that lead to that being an offence. Strict liability means that that's like the bottom dollar line at law. Okay, we're going to keep scrolling up because we get to 5. Because 5 is kind of relevant to 7.3, mental impairment, Pauline. 5 talks about recklessness and fault elements. A fault element for a particular physical element may be intention, knowledge, recklessness, or negligence. Intention. A person has intention with respect to conduct if he or she means to engage in that conduct. A person has intention with respect to a circumstance if he or she believes that it exists or will exist. A person has intention with respect to a result if he or she means to bring it about or is unaware or is aware that it will occur in the ordinary course of events. So the intent before the judiciary to lay down a curial right was defined. And that makes it not a mental impairment, Pauline. Okay, so we're looking at the legal definitions here of things. And do you have an intent to carry on believing that you have lawful authority after being in cahoots with, by your oath, a group of people that have committed heinous international criminal offences? And this brings to the 5.3, knowledge. A person has knowledge of a circumstance or a result if he or she is aware that it exists or will exist in the ordinary course of events. You've been now made fully aware, Pauline, of the circumstances laid out at the Supreme Court after your New South Wales police committed heinous international war crimes, including Rule 90 and Rule 92 offences many years before any lockdowns took place, Pauline. Recklessness, 5.4. A person is reckless with respect to a circumstance if he or she is aware of a substantial risk that the circumstance exists or will exist. Now, is there a conspiracy going on within the Parliament, Pauline? Are they trying to undermine the Constitution within this conspiracy, Pauline? It's very clear. Like, you can't use a sovereign people to undermine our Constitution. You've got to kick them out and make them sovereign, Pauline. Is that reckless? That's knowledge, you know. Is it reckless to do that? Of course it is. Having regard to the circumstances known to him or her, it is unjustifiable to take the risk. It is totally unjustifiable what you're trying to do. It is totally reckless. And not you, Pauline. We're talking about Albo here and the conspiracy that he's been called out at within the office of Prime Minister. Okay, so 5.5, negligence. A person is negligent with respect to a physical element of an offence if his or her conduct involves such a great falling short of the standard of care that a reasonable person would exercise in the circumstances. Albanese has shown grave negligence over the Uluru Statement. This is very evident by the media presentations and the words that are circling around that very media today, Pauline. These are criminal offences, and these are specific fault elements to those criminal offences, Pauline. You can't deny this stuff anymore, Pauline. Such a high risk that the physical element exists or will exist, that the conduct merits criminal punishment for the offence. Negligence, criminal punishment, Pauline. And we're talking about sabotage of a referendum, Pauline. And we're talking about him backing away from a document of which he had full knowledge of, going to Garma and being involved with all of this since the beginning. We all know this. So is that intent? Because that's a fault element up the top here. A person has intention with respect to conduct if he or she means to engage in that conduct. And we just saw Albo go to Garma. Okay? That's intent. And then to now turn around and say he knows nothing about all this stuff when the intent was shown, that's negligence. And that leads to recklessness, Pauline. These are all fault elements that our Prime Minister has fallen into. Offences that do not specify fault elements. If the law creating the offence does not specify a fault element for a physical element that consists only of conduct, intention is the fault element for that physical element. If the law creating the offence does not specify a fault element for a physical element that consists of circumstances or a result, recklessness is the fault element for that physical element. Recklessness is the fault element. A person is reckless with respect to circumstances if he or she is aware of a substantial risk that the circumstance exists or will exist. They are opening the door to the manipulation of the Constitution without defining the specific wording of a legal document at which they wish to change. Nobody in their right mind is going to say yes to something that is an open blank check. Recklessness, negligence, intent, and knowledge These are all of the 4 fault elements that Albo falls into, knowing what he's done. Now, having backed out what he's done, and we can't condone or even excuse the Greens, Adam Bandt and Lydia in all of this, Pauline, because they are intoxicated on that power, aren't they? Intoxication at 8 here. Self-induced intoxication, involuntary awe as a result of fraud, sudden or extraordinary emergency, accident, reasonable mistake, duress or force. It doesn't mean getting drunk all the time. It can mean being deluded and intoxicated of your thoughts, Pauline. Okay? Intoxication. It's unbelievable that someone who is just sitting at home can point all of this out, and all of you that work as senators are unable to, incapable of, unwilling to, and it's up to us to bring about the court of public opinion for your very own negligence and your very own failures under these laws for not dealing with this situation, which leads to the fact that you may have, under Criminal Code 7.3, as senators, a mental impairment. The question whether the person was suffering from a mental impairment is one of fact. It's on the Supreme Court record that this is deluded, delusional, Pauline. That puts you in this position of having to prove that you do not have a mental impairment when it comes to, I'm scrolling back down again, 9.5, a claim of right, and 10.5, lawful authority. This also then leads us back into 11, attempt, complicity, common purpose, joint commission, commission by proxy, incitement, and there's that big one we've all been talking about. Criminal Code 1995, 11.5, conspiracy. A person who conspires with another person to commit an offence punishable by imprisonment for more than 12 months or by a fine of 200 penalty units or more commits the offence of conspiracy to commit that offence and is punishable as if the offence to which the conspiracy relates has been committed, and nobody has been held liable for any of the actions of the last 15 years, Pauline, and we're looking at a government that is now currently being accused of some very serious things. Very serious things, Pauline, including conspiracy at law.